Hello, everyone, and welcome to Uncivil Law. For today's case, we are dealing with a felon in possession case and dealing with whether or not this person should have to serve more time as a result of being a felon in possession of a firearm. This is the case of United States of America versus McKella in the Ninth Circuit. In this case, a person was convicted of having a firearm, and he argues two things. First, that he wasn't a felon, and second, that some of the felonies shouldn't count. So we are going to read the case from the Ninth Circuit and read about what happens when you're a felon caught in possession with a gun and what does or does not count in terms of sentencing enhancements for the Armed Career Criminal Act. Let's get started with this. On February the 7th, 1997, McKella was convicted of possessing a Lorson .380 caliber semi-automatic pistol and a Marlin .22 caliber rifle. Appellant excerpts of record. Under 18 U.S.C. 922 G1, convicted felons are prohibited from possessing firearms. The statute provides it shall be unlawful for any person who's been convicted in any court proceeding of a crime punishable by for a term exceeding 1 year to receive any firearm or ammunition which has been shipped or transported in interstate or foreign commerce. So just by way of example, we often call it in short, and lawyers even call it in short, convicted felons. But the way the statute is written, it is written to apply to any crime that has a maximum possible sentence of more than 1 year. Now, traditionally, those would be felonies, but a lot of states have misdemeanors which go beyond 1 year. So it's not an issue of being a felon in possession. It's an issue of being convicted of any crime, the sentence of which is more than 1 year. That has the potential to be more than 1 year. So if the maximum possible sentence is 5 years, but you're given probation, you count. The question is the sentence that's possible, not the sentence you got. So any crime that has a maximum possible sentence of more than 1 year is disqualifying under 18 U.S.C. 922. So just a little aside there, it's not just felons. Section 921 provides, among other things, any conviction which has been expunged or set aside, or for which a person has been pardoned or civil rights restored, shall not be considered to be a conviction for the purposes of this chapter, unless such a pardon, expungement, or restoration of rights expressly provides that the person may not ship, transport, possess, or receive firearms. So if you have your rights restored, if you're pardoned by the relevant authority, if any of those things, then you don't disqualify unless they say, yeah, you still disqualify, which I don't think typically happens. Usually if you're pardoned or something, they won't go the extra step of just saying, and by the way, you still can't get your guns back. But yeah, that's the thing. If your conviction is set aside for some reason, the crime, it doesn't count anymore. So first thing is, was this guy's conviction set aside? All right. In 1980, McKella was convicted of 2 counts of burglary, which is a felony in the relevant jurisdiction. McKella received a conviction for selling narcotics drugs, also a felony, in 1985. That'd be a second conviction. McKella claims he believed his civil rights were restored under Arizona law in 1992, and he could lawfully possess a firearm. He reasoned that because the state of Arizona approved his application for a voter registration card, called him for jury duty, and permitted him to vote in several elections, his civil rights were restored. Consequently, he claims that the district court should have instructed the jury that the government has the burden of proving beyond a reasonable doubt that his civil rights are restored. So make a note here that he's arguing a thing in fact. There would be a later case that would deal with your knowledge of it. So he made the wrong argument. Because if his argument would be, oh, I didn't believe it, then that would be a war thing. But he's arguing it in fact. So the Ninth Circuit is coming out away because of the way he argued it. There would be later cases that would say that the government has to prove beyond a reasonable doubt that the person was aware they were a convicted felon. So, but this case isn't raising that issue. This case is raising whether it was true in fact, not his own knowledge of it. So different legal issue, different legal result. So he asked the wrong question, I guess. So the question is, did it in fact exist? Not was he aware of it? So he raised the wrong question. We look to state law to determine whether a defendant's civil rights were substantially restored, which would be the case if it's a state-level conviction. Obviously, if it's a federal conviction, you'd look to federal law, but in this particular case, you're looking to the relevant state law. The state of Arizona, where McKella was convicted, automatically suspends the right to vote, hold public office of trust or profit, serve as a juror, possess a gun or firearm, or any other civil rights necessary while such a person is imprisoned. So those rights are suspended while you're in jail, which I suppose is fair enough because a lot of your constitutional rights are significantly impacted by being in jail, not the least of which is your right to freedom. However, after discharge from prison, a convicted felon may, and this again is Arizona state law, so before you go run off on this, make note that your state law may vary. A convicted felon may have any civil rights which were lost or suspended by his conviction restored by a superior court judge whom the person was sentenced, or his successors in office from the county in which he's originally sentenced. So the judge who originally sentenced you or the position can give you your rights back. It's a possibility. McKellar claims that he petitioned the Maricopa County Superior Court to have his civil rights restored in 1992. I asked, although he did not receive any communication regarding his application, he applied for a voter registration card approximately 6 weeks later. McKellar testified that when he applied for a voter registration card, he signed a statement that he had never been convicted of a felony, or that if he had, his civil rights had been restored. He stated that he signed it because he felt that his rights had been restored. He also testified that he never received any correspondence from the court informing him that his civil rights had been restored. So he says, oh, I filled out an application and they never sent me anything back. That must mean that my rights are restored. No, you kind of have to follow up on that. You know, you have to actually get the order signed by the judge. So I filled out the paperwork does not make your rights come back. No, that doesn't work. We find that McKellar's civil rights were not restored, and he had no reasonable expectation that they would be. Under the relevant Arizona law, a convicted felon is not allowed to apply for restoration of civil rights until 2 years have passed from the date of the absolute discharge. Here, McKellar testified that he had received his absolute discharge in April of 1992, and he waited approximately 2 weeks, which is substantially shorter than 2 years, before he went and filled out the application for restoration of rights. So, under the relevant Arizona law, you have to wait at least 2 years before you ask, presumably to make sure that you've been at least reasonably law-abiding. And he said, oh, I saw the number 2, and I thought it meant weeks, not years. No, sorry, years. So your rights were not restored, and also they didn't tell you they were, and also you're a convicted felon. So just no to any of those things. So no. Because we find McKellar's civil rights were not restored, the district court did not commit reversible error in its charges to the jury, informing him that he was in fact a convicted felon. Fair enough. Okay, so he is now a convicted felon in possession of a firearm. This is bad. But it depends. How bad is it? Because the level of bad depends on the nature of your crimes and how many there are. So if you've only been convicted of one offense, it's not as bad as if you've been convicted of more than one offense. So the number of previous crimes of more than 1 year that you've been convicted of matter. And so his next argument is, the number of crimes the district court thought I committed is not the same number as the crime I committed. And you're going to see it makes a pretty big difference when it comes out to the actual sentencing. It's a pretty big difference how many prior crimes there are on your record. So let's talk about the difference it makes and which of these categories he falls into. We reviewed from the start the application of the Armed Career Criminal Act, 18 U.S.C. 924. The statute provides, and this is the part where you want to pay attention if you're a bad guy, in the case of a person who violates 922 of this title and has 3 previous convictions by any court referred to in 922 of this title for a violent felony or a serious drug offense or both, committed on occasions different from one another, such a person shall be fined not more than $25,000 and imprisoned not less than 15 years. So, yeah, if you have been convicted of 3 prior felonies or 3 prior crimes of this category, violent crime or serious drug offenses, the sanction is a fine of not more than $25,000, which, you'd probably be willing to pay if it got you out of it, and imprisonment for not less than 15 years. So it's the difference between him serving 5 years imprisonment and 15 years imprisonment. So that makes a bit of a difference. McKellar does not dispute that his 1985 conviction for the sale of narcotics qualifies as one of the previous convictions within the meaning of the statute. He, however, claims that his two burglary convictions in 1980 do not constitute felonies committed on different occasions from one another. So he has 3 prior crimes. That is not in dispute. But the question is essentially, are they different crimes? Are they different enough? So if they're part of the same criminal transaction, which is very fancy words for saying basically they're contemporaneous in purpose or time, then they don't count as separate for this purposes. They count as separate for other purposes, but not this purpose. So he has 1 prior drug conviction, and he also has 2 burglaries, which may or may not count as 2. If they count as 2 for this purposes, he's in trouble. So he'd like them to count as 1. So let's figure out if his 2 prior burglaries actually count as 1 or not. The statutory language, committed on occasions different from one another, is ambiguous on its own face. When a statute is ambiguous, we may look to legislative history as a guide to its meaning. The predecessor statute to the present Armed Career Criminal Act did not include this language, committed on occasions different from one another. So this was an addition to Congress, and therefore, being an addition presumably meant something different than what used to be there, because Congress probably doesn't just add words for the heck of it. So having added words, those words probably have some significance. The Armed Career Criminal Act was amended to prevent the application of an enhanced sentence to a defendant who committed simultaneous crimes, regardless of how many convictions resulted from those actions. Congress intended for enhanced sentences to be applied when a defendant was guilty of committing multiple crimes that took place over a different period of time, or to use more fancy language, occurred as part of a different criminal transaction. Clearly, Congress meant for this provision to reach career criminals that's shown that they cannot be rehabilitated. So the Ninth Circuit says that the language seems to suggest that they have to be different transactions. So even if you commit multiple felonies during the same transaction, they don't count as separate, because we're looking to people who have a history of bad behavior over time. All right. The leading case in our circuit on the interpretation of this is a case called Antoni. In Antoni, the court found that 2 robberies committed 40 minutes apart and 2 cities against different victims were 2 separate and distinct criminal episodes. Consequently, the crimes committed on different occasions from one another. So 40 minutes apart in 2 different cities against different victims were distinct enough in that particular case. However, the Sixth Circuit's reasoning in Murphy follows our understanding of the intent of Congress. The record before us does not contain any information regarding the amount of time Micaiah spent in each store of his burglaries, or whether he stayed in one store while his accomplice entered the other store, which would suggest as part of a common transaction. If you are engaging in conspiracy and one person robs one store and one person robs another store, that suggests as part of a common criminal transaction. Consequently, we cannot say the burglaries committed were separate and distinct criminal episodes. Rather, we hold McKell's arts were part of one criminal episode. So McKell here gets a break on the basis that the record's not clear enough one way or another. And because it's a criminal statute, the criminal law is to be narrowly construed. So we don't hold people responsible for things the record doesn't reflect. So we're not sure if they're distinct or not, therefore they're not distinct. Because, we give breaks to the bad guys in our criminal system, which is probably for the best. McKell committed 2 identical crimes in basically the same location within a short period of time. He does not meet the profile of a career criminal envisioned by Congress. Consequently, we find that McKell's 1980 burglaries were not committed on occasions different from one another, and the district court erred in enhancing the sentence in this way. The court conviction is affirmed, the sentence is vacated and remanded for resentencing in accordance with this opinion, which as a practical effect means that he's getting a 10-year discount on his sentence, so lucky for him. Thus, this is the end of our coverage of United States of America versus McKell. In this case, we learned a couple important details. 1, just because you filled out the form saying that you think that you're no longer a convicted criminal doesn't mean that your rights have been restored. They actually have to be restored. And also, you couldn't even apply because the time period hadn't lapsed. So no, your felonies had not been eviscerated. So you're still a convicted felon. However, you're only a twice convicted felon, because the 2 burglaries that you did essentially merged because they were part of a common criminal enterprise, or at least it's not clear enough that they weren't. So Mr. McKell here goes back to resentencing. We'll get a 10-year break on his sentence as a result of this, but for the moment, that's the end of the coverage of this case. Thank you so much for being part of the Uncivil Law family. If you liked this latest video, please give it a like below and hit the join button. For 99 cents a month, you too can give a recurring membership that helps this channel grow and helps YouTube to recommend this channel to others. We really appreciate your continued financial support and all your love. And until later, my friends, cheers and goodbye.